I'm back with Danielle D'Souza Gill, author of the book The Choice. It's kind of a striking opening quote here. Men occasionally stumble over the truth, but most of them pick themselves up and hurry off as if nothing ever happened. Winston Churchill. I think this is kind of telling about the way in which we avert our gaze from the reality of abortion. Well, we're here talking about the Supreme Court's decision to take the Mississippi case, a case that involves essentially prohibiting pretty much abortion after 15 weeks. Dee, let's talk about the court, because do you think that the court is, you said earlier that you don't think that they're ready to sort of take a hatchet to Roe v. Wade, to strike the tree at the root. Why is that?
I think they're worried about them packing the court, the Biden-Harris administration. So they don't want to anger the left too much. I think that they're worried about the long-term kind of independence of the court, the long-term results of what the court will be. Will there be a court with the same amount of justices we have now, or will there be 50 because the left packs the court, then conservatives come in, they pack the court, and so on, and it's really never ending. So I think that they want to protect the court, and that's why they're a little bit squeamish about acting in even in line with what the Constitution says sometimes. And so I'm a little bit skeptical of whether this will be a real hatchet to Roe v. Wade.
I mean, kind of what you're saying is that this court packing scheme of the left is already working. Even if they haven't passed it, it exercises an intimidating influence on the court. And you're saying not just in the abortion case, but in other cases. Let's talk about some of those other cases, because talk about ways in which the court has, you may say, split the difference instead of going all the way in some of the other cases. Which other cases are you referring to?
One case that comes to mind was regarding Gavin Newsom, governor of California, and how he had restricted churches and other religious institutions beyond how he was restricting restaurants and things like that. So the court took the case and said that he can restrict them as much as he wants, but it has to be in line with how much he's restricting other types of institutions as well. And I just read that as very, very, very much a big compromise, because the Constitution states that it's not up to the governor to restrict our religious freedom. It's not up to the governor to restrict those things. And so they allowed him to restrict churches to 25% capacity. Let's
put this a slightly different way. What you're saying is that the court offers a specific protection for religious freedom. It doesn't offer a specific protection for your freedom to go to a bar or go to a salon. And so the Supreme Court, in basically saying to Gavin Newsom, treat all these institutions the same, is ignoring the special protection for religion in the First Amendment, right?
Exactly. And even if we look at our Second Amendment, which states it shall not be infringed, it has been infringed. There are many liberal states that don't allow you to conceal carry. They really don't allow you to have any kind of self-defense in any way. And so that shows it's been infringed. Does the Supreme Court really care? I don't know. Are they actually acting by looking at the Constitution, or are they really considering politics? So I think when it comes to this issue, I think they might try to maybe roll back a little bit Roe v. Wade, but I don't know how big of a victory it will be considering the Supreme Court's recent actions on other issues.
So even though there's no abortion right in the Constitution, it's essentially a fiction. Now, although it is a constitutional fiction, I think it is fair to say that abortion has become embedded in American cultural life, right? In other words, since Roe's now almost 50 years old. It'll be 50 years old in a couple of years. Abortion has become accepted. And so when the left talks about precedent, I don't think the legal precedent matters, because precedent built on a bad foundation means nothing. But the truth of it is, it has become precedent in the sense that Americans, for most of our lives, have gotten used to this, have gotten used to abortion being there and being available. Do you think the court might be scared about that, scared about trying to uproot a practice? Now, admittedly, segregation was also, part of American culture, at least in certain parts of America. My question is, do you think the court will be reluctant to change Americans' habits in a fundamental way on this issue?
Absolutely. And I think just as with segregation, they will have to say, just because the court affirmed this before doesn't mean we can't throw it in the ash heap of history, like Plessy versus Ferguson. And they'd have to start with something like looking at and segregation, the discrepancy between schools. So in this situation, they've decided to look at 15 weeks. And I think that that'll show a lot, because 15 weeks is when they're performing suction abortions, a surgical abortion. And by the time at the end of the first trimester, the child already has every organ it needs for its entire life. So from there, it really just continues to develop. And so I think the technological advancement since Roe v. Wade, all of this should be a catalyst for the Supreme Court to reconsider this.
Now, 15 weeks, interestingly to me, is fairly close to an important concept in Roe itself, which is the concept of viability, the concept of the fetus being able to live outside the womb. And I wonder if that's going to be where the court is going to go, because in this way, they don't even, in a sense, have to overturn Roe. All they have to say is, we need to go back to what Roe originally said by defining this concept of viability. Maybe what the court will say is that the fetus is part of the woman's body until it's viable, and after that, states do have the power to regulate. I wonder if they will draw the line there. What do you think?
I don't think so, because viability is a little bit later, so that wouldn't be as connected to this 15-week marker. But I think the heartbeat, something like that, would be much more of a win for the pro-life side rather than viability, which can oftentimes go closer to the third trimester.
Talk about the ways in which the pro-life movement can lose by winning. In other words, that they can get something, but it's so little that it will drain perhaps the pro-life movement in some ways and give the left the momentum on this issue, because you're worried that the court might actually side with the pro-life movement, but not enough to make a meaningful difference.
Right. So I think if they only roll back Roe v. Wade a little bit, there will be some pro-lifers who celebrate that. Of course, any life saved is worth tremendous effort. So that is still a win, but we can't let that be an excuse to give up or to stop fighting for all the other lives that will still be lost because of these pro-abortion Supreme Court decisions. So I think a small win is definitely a little bit of a mixed blessing.
Yeah, that's very interesting. Now, say a word about these new justices, because Trump, we seem to have a 5-4, perhaps even a 6-3 if you count Roberts in the mix. Kind of, who are the justices that you think we can solidly count on to be foursquare against Roe, and who are the guys that you think might be doing the tap dance in the middle?
Well, I think Clarence Thomas, he will absolutely be against Roe v. Wade, because he's written about the eugenics used in abortion, how so much of Margaret Sanger's ideology, Planned Parenthood's ideology, has killed a lot of Black babies. He's written about that. I think Justice Alito will probably fall in that same situation. I think the newer justices, like Gorsuch, Kavanaugh, and Amy Coney Barrett, might be a little bit more wary of being more hardcore against Roe v. Wade because they were appointed by Trump, because they're newer to the court, and because they might be more fearful of the left. And so...
Wow, what you're saying is actually the Trump justices might be the ones who have the trepidation about going all the way. In that sense, they would, we may say, lack the Trumpian spirit that put them in office in the first place. Hey, Dee, thanks for coming on the podcast. This is awesome. Very interesting discussion.
Thank you.